To the Sustainable Scale Up Cluster webinar for the Bridging the Gap cohort. This is being run by Capital Law, and they will be covering some information for us around sort of the legal side of trading, understanding trading vehicles, and also intellectual property. So I'm going to hand over to the Capital Law team and hand over to Kerith first. So over to you. Thank you.
Thanks, Andrew. Yeah, good morning, everybody. So just by way of sort of quick, brief introduction, my name is Kerith Bevan. I'm a solicitor in the corporate team at Capital Law. And doing the presentation alongside me today is my colleague Sarah Morgan. Sarah is a solicitor in the commercial team at Capital Law. So myself, I tend to work on for companies and businesses on things like investments, mergers and acquisitions, and general corporate governance. And then Sarah and the commercial team works on things more like the contract side of things, data protection, and things like intellectual property, which you're going to be adding a bit more on during today's presentation. So if I just quickly run through the agenda for today's presentation. It'll be split into three segments mainly. So first section will be my bit around the different types of trading vehicles, and then why typically companies limited by shares are the most popular form of trading vehicles that we see, and then the setting up and management, the practicalities of setting up and managing companies limited by shares. And then the second section will be Sarah covering intellectual property, why it's so important for businesses to protect it, and then moving into the specific types of intellectual property and the merits around those. And then the third section will just be a quick Q&A based on what we've presented and any additional questions that anybody has. So if I just make a start then with my section on the different types of trading vehicles. So alongside all of these slides and the different types of vehicles, you'll see that I've added key features for all of them. So starting off with sole trader as a form of legal entity. So the key factor is that small businesses operated by an individual often adopt sole trader format because there's a lack of legal formality and there's low administration costs involved in setting up and running the business. So in practical terms, it just means that it's a bit easier to set up compared to other types of trading vehicles. So key features, sole trader has no separate legal personality. So what that means is there's no legal separation between the business and affairs of the sole trader. Business operating as a sole trader cannot own its assets in its own right or grant security over them. And sort of linked to this is the fact that sole trader has unlimited liability. So what that means is that the sole trader, the individual behind the business, is personally liable without limit for all debts and liabilities of the business. There's no need for a sole trader to adopt constitutional documents, and there's no requirement for a sole trader to file accounts and other documents with Companies House. So what that means is just practical terms, it's a bit easier to operate a sole trader from an administrative perspective, and sole traders' details won't be shown on the public register, for example, Companies House, like you would see with some of the other forms of trading entities that I'll be covering later on. So moving on to the second type of trading vehicles, general partnerships. So general partnerships are governed by Partnership Act 1890, but in practice you usually see that partners enter into standalone bespoke agreements that govern their relationship as partners, and that better suit the circumstances around the partnership that's ongoing. Again, partnerships have no separate legal personality. So again, partnerships separate legal personality. Sorry, partnerships legal personality is not separate from the partners itself. So the business operating as a partnership cannot own its own assets and cannot grant security over the assets. And then likewise with sole trader, partnership has unlimited liability. So the partners involved have joint and several liability for all debts and liabilities of the business. And obviously, by its very nature, the partnership must have at least two participators to be able to exist.
Gareth,
Partners
please.
are not required.
Sorry, I know we said questions at the end, but you said this twice, and I just need it clarifying. Where you said owning assets under no separate legal personality, was that it? That they can't own assets? Please, can you just clarify that?
Yeah, so hopefully when I move on to covering companies limited by shares, it'll add a bit of context. So if you contrast it with companies limited by shares or limited companies generally, when a company buys an asset, like I don't know, a property, for example, the asset is owned in the name of the company. Mm-hmm. Whereas in a partnership or a sole trader, it won't be owned by the business in its own right. It's it's owned by the person that sits behind the vehicle. Okay. If that makes sense.
Okay.
So that's where it ties in then with the unlimited liability, because say the business, say a company was to buy a property, not a company, a partnership was to buy property and had a mortgage behind it and was to default on that mortgage. The fact that it has unlimited liability would mean that the lender would be able to go behind the partnership and essentially go after the partners itself. Whereas with a company, it would go after the lender would go after the company. That's one example, or the most kind of popular sort of example to use in that context.
Okay, I understand now.
Hopefully that's it. Yeah, no problem. So moving on to my next point around general partnerships, and again, similar to sole traders, there are no need for constitutional documents, and there aren't any administration and filing requirements with Companies House. So again, that just means, practical terms, it's a bit easier to operate and manage than a company who do have these obligations, which I'll go into in a bit more detail further on. So the next type of trading vehicle I'm going to cover is limited liability partnerships, LLPs, which is on the next slide. So an LLP is a hybrid form of entity that combines the benefits of a limited company with the flexibility of a general partnership. In contrast to general partnerships, an LLP has separate legal personality. So this is a good example, is that it can own its assets and grant security over them in its own right, compared to partnerships which can't, and sole traders which also can't. It can enter into contracts in its own right, and it can sue and be sued in relation to those contracts in its own right. Again, it has limited liability. So an LLP is liable for its own debts. The business liabilities and debts are the responsibility of the LLP, not its individual members. The members' financial exposure, so the LLP members' financial exposure is limited to their capital investment in the LLP. An LLP has no share capital. There are no capital maintenance requirements unless that's otherwise been agreed between the members. And there's no obligation for members to contribute capital into the LLP. LLPs are subject to ongoing filing and disclosure obligations, which are broadly the same as companies, which I'll go on to in a bit. Such obligations include the need to file things like annual accounts, confirmation statements, and then notify of any changes to its registered particulars. So, for example, if there's been a change to the LLP's membership. And a fee is also payable for some of these filing obligations. So moving on to the next form of trading vehicle, and the most popular that we come across, companies limited by shares. So similar to limited liability partnerships, a company does have separate legal personality. So it can hold its own assets, it can grant security over those assets in its own right. And again, it can enter into contracts in its own right and be sued, can sue and be sued in relation to those contracts. Again, it has limited liability, so it's liable for its own debts. Limited liability, not unlimited liability. It's liable for its own debts, and the liability of each shareholder of a company, the liability of each shareholder in relation to the company's debts or liabilities is generally limited to the amount which remains unpaid on that shareholder's shares. There is no statutory upper limit for the number of shareholders that a company must have, so it can be formed with just one shareholder, or it can have hundreds of shareholders if it wants. The owners of the company are its shareholders, and the responsibility for the management of the company generally falls to its directors. But in many instances, you find that the directors of the company are also its shareholders. A company limited by share has an issued share capital, which is made up of the money that's been paid by the shareholders for their shares in the company. And similar to an LLP, again, companies are subject to extensive ongoing filing and disclosure obligations. So it has to file annual accounts, has to file annual confirmation statements, and then there are other event-driven obligations that it will need to file with Companies House too, such as the obligation to notify of changes to a share capital, any directors that have been appointed, or other registered particulars. And the fee is also payable in relation to some of these ongoing filing requirements. So that's a sort of quick whistle-stop tour of the main trading entities. The other one that I'll just quickly run through is a company limited by guarantee. So this is very similar characteristics to a company limited by shares, but it's normally incorporated for non-profit making functions. So the members of a company limited by guarantee undertake to contribute a predetermined nominal sum to the liability of the company, which becomes due only when the company is wound up, and a contribution is needed to enable it to pay its debts. The amount that members undertake to contribute isn't an asset of the company, but it's a contingent liability of the members to contribute in the event of a winding up. Members are liable to contribute whilst they are members of the company, and within 1 year of ceasing to be a member. So yeah, that's pretty much the main forms of trading entities that we come across. But like I covered, a company limited by shares is the most popular. So I'll just sort of explain in a bit of detail the sort of practical reasons why they tend to be the most popular. So companies are run separately due to the separate legal personality that they have. So third parties such as landlords, clients, and suppliers will enter into contracts with the company itself rather than with you personally, and the staff will be employed by the company itself. And as mentioned earlier, it has limited liability. So the shareholders of the company have a capped liability for the debts, losses, or legal claims of the business. Their liability is limited to what they pay for their shares. So if you contrast this with sole traders or partnerships, there's potentially unlimited liability. So your personal assets, such as your private residence and your savings, could be at risk to settle the debts of the business if it's run as a partnership or as a sole trader. But one major exception to this in the case of company is in the event of fraud, where personal liability of directors are unlimited. The other factor that makes companies very popular, companies limited by shares, very popular, is credibility and prestige. So formation of a private limited company can suggest that the business has permanence and is committed to effective and responsible management. It gives both suppliers and customers a sense of confidence. Many companies, particularly larger organizations and government organizations, won't deal with a business that isn't a limited company. So forming a company can therefore open up new business opportunities that perhaps wouldn't otherwise be available. Raising capital. So sole traders and partnerships generally have to raise capital from their own resources, whereas companies can raise capital by issuing new shares. New shares can be offered to existing shareholders or new investors. It can create new classes of shares as well to offer flexibility. And then these different classes can have different rights on things like voting, receiving dividends, how capital extracted if the company is wound up or sold. So as founders of the companies, you might want to keep hold of a better rights to your shares, attached to your shares, compared to perhaps an investor's rights behind their shares. Companies can also benefit from tax advantage schemes such as Enterprise Investment Scheme and Seed Enterprise Investment Scheme that are specifically targeted at companies raising capital by issuing new shares. Some grant funding might also be available to businesses set up as companies. If the company is going to borrow money from a bank, it's possible that it could secure lower interest rates than that for a sole trader. It may also be possible to obtain a loan without the need for directors to give personal guarantee, or the person standing behind the business to give a personal guarantee. So in contrast, sole traders may face the prospect of having to put a mortgage over their own home to secure a new loan. And then exit options. So when registering a business as a limited company, that can aim the possibility of selling it in the future, which can be difficult to achieve with other business structures. The owners may be able to achieve a clean break and receive financial benefit by selling their shares. So there's entrepreneur relief against capital gains tax that might be available on the sale of a company. And then the company will, if successful, be a valuable asset in its own right that you could sell as its owner. And IP ownership. So obviously Sarah will be going into a bit more detail on this, but you can protect your company's name and the intellectual property created by your company that would be owned by it and reflected, that can be reflected in the value of the shares in the company as well, compared to a partnership or a sole trader, which it can't benefit from. So that's sort of main kind of reasons why people tend to opt to run their sort of businesses as a company, as opposed to the other forms of trading vehicles. And then in terms of setting up and managing a company and the practicalities around that, so there's the next slide. Incorporation of a company can be done online or by post. It can cost as little as £10 to incorporate, and it can be done within a few hours if it's urgent. Company must have a unique name, one that isn't already in use. Management of a day-to-day company, as I briefly mentioned earlier, is carried out by its directors under the terms of the company's articles of association. And often you find companies have what's called model articles, which is provided under the relevant legislation, which is the Companies Act. There are certain instances which things must be approved by the company's shareholders. So, for example, changing a company's name, appointment or removal of company's directors, updating a company's articles itself, and so on. In terms of administration, you need to file annual accounts with Companies House and annual confirmation statements. And then there are certain event-driven filings that are required, like I mentioned earlier. And some of these do also incur filing fees. So in terms of administrative requirements, companies probably have the most burdensome compared to other types of trading vehicles. But you can appoint somebody to carry out company secretarial advice on your behalf. And this reduces the administrative strain on you to make these filings, and that's something that we do at Capital Law. Members of the public will be able to see some of the company's details. So, for example, its accounts, some personal details of shareholders and directors, unless you have elected to keep your address private. So those are the sort of main practicalities of setting up and managing a company. And that brings my segment of the presentation to a close. So I'll pass the baton on to Sarah, who's going to cover off intellectual property and the wonderful world of IP.
Thanks, Cara. Good morning. Before we get started, just want to say please excuse any sneezing, or if it looks like I'm going to cry. The pollen count today is awful, so it's not been good. Anyway, I'm here to give you a whistle-stop tour on intellectual property and how and why you can protect it. So intellectual property, or IP, refers to creations of the mind. So that includes inventions, literary works, designs, names, symbols, all those kind of things. And IP is protected by law. There are various types of IP rights, and you've got copyright, trademarks, patents, design rights, and trade secrets. There are other types of IP, but these are the main ones that I'll be talking about today. So at Capital, part of my role is to help companies sell or buy, transfer or license IP to others. For example, previously we've been involved with Clark's maple syrup, the thing you put on pancakes. We'd acted on the sale of the company to Hain Celestial, and they own Sunpat, which is peanut butter, and previously Tilda, the rice. So, why should you protect and enforce your IP? So there's a number of reasons to protect your IP. And firstly, protection or registration helps protect your work and your labour. So the protection can help maximise the value of your business and act as a warning to others not to copy or exploit your work. It can also help you gain a competitive advantage over others. So if you're a small business, it's vital to protect any unique products or services you have. It helps stop competitors from using your ideas as their own. And ultimately, if they do that, they may take away some of your market share. So let's get into the detail. Copyright. Right, so first up, we have copyright. It protects artistic, dramatic, literary, and musical works as long as they're original. So that covers things like books, paintings, the latest episode of The Last of Us, they're all protected. But they do have to be original. So the author or creator must have created the work through their own skill, judgment, and individual effort. So, if the slides work, yeah. Okay, so copyright also protects technical innovations like computer programs and software, but it won't, for example, protect a recipe. So while a recipe written down will be protected by copyright in the way it's written down in the format, it would stop someone republishing that, but it won't stop someone from following the recipe and making that dish. And protection lasts for the life of the author plus 70 years. Thankfully, in the UK, you don't have to register copyright, so it's an automatic right. But to gain that automatic right, the work must have first been published in the UK, so not outside. And that's why it's really, really important to make sure you keep track of what you're creating and when you're creating it, and also who is creating it. Because one of the big problems we find with copyright is ownership. So usually the first owner of copyright is the author of the work, but there are exceptions. So generally, where the copyright work is created during the course of employment, the employer owns the work. That's not always true though. For example, if someone is making this outside of their work hours, outside of what they're doing, businesses really need to have contracts in place with their employees. So you'd have employment law contracts to deal with their employment, but within that you can include these IP provisions which state that the employer will own the copyright if anything is developed within the workplace or during the course of their employment. You've also got contractors. So an example of this is where you ask someone to design your website. Even where you pay them, you as the business do not own the IP. So that's why it's key that parties enter into an agreement transferring the intellectual property, and that's known as an assignment. Now, this is a really common pitfall for companies, and I can't tell you how many companies find out much later down the line that they don't own all of their IP. So basically, make sure you've got everything in order, know what your IP is and what you're doing with it. So, as I mentioned, assignment of IP is a common issue. And when you're assigning, you need to make sure that the assignment is in writing and signed by the author. So with the website developer, you need to make sure that it's in writing and they've signed over that IP in the website to you. A license, which means where you license your intellectual property for somebody else to do something with, that also needs to be in writing and be specific on what is being licensed and what they're allowed to do. So the person giving the license retains ownership of the IP right, but the person receiving the license can engage in specific acts, which would technically be infringing if the license wasn't in place. In terms of evidence of ownership, businesses should always retain records of IP transferred and agreements in place, and written agreements are always relied on as evidence later down the line, particularly if there's a dispute. You'll also find one of the major issues is infringement, and that involves copying a substantial part of the work, or issuing copies of the work to the public, or renting the copyright work. So I'm hoping some of you remember when you go to Blockbuster and you rent a film from Blockbuster. I know it's quite old-fashioned now. I think there's only one Blockbuster left in the world. When you play it, you get that advert that's like, you wouldn't steal a car, you wouldn't do this. That's copyright infringement because you're copying that illegally. Not when you've got from Blockbusters, but if you were to copy it. And then very briefly on enforcement, you might be able to ask the court for an injunction to stop the use of the infringing work or to be able to seize the copies of that infringing stuff. So next up, trademarks. So trademarks are incredibly important for all businesses, and I've set out some examples here. Also, our capital law one is in the middle. So you'll often hear the trademark and brand used interchangeably. So both are referring to marks which differentiate a company's goods or services from those of other traders. So what sort of things are trademarks? Well, you've got words, so brand names like Coca-Cola or Microsoft. You've got letters and you've got numeral combinations. You've got logos like Apple or Facebook here. You've got designs, so the Adidas 3 stripes. You've got shapes, so McDonald's has registered the golden arches, the M. And you've also got Toblerone and Kit Kat are registered as trademarks, the shape of them. You've also got colours. So Heinz registered the colour turquoise for use on its tins of baked beans. And you can also register non-traditional trademarks like sounds, scents and tastes. They're a bit more difficult to register, and different places have different jurisdictions, like different countries. They have different prescriptive things on what you need to do. So sounds would be something like the Intel jingle. And then in the US, they have, I believe, registered the smell of Play-Doh, which I'm sure you are all now thinking of. So trademarks are registered into certain classes, which are set out in a classification system, and these cover goods and services. So what is a trademark? So a trademark is a sign that's capable of distinguishing the goods and services of one business from those of other businesses. Now, when you register a trademark, as the owner, you get the right to exclusivity. So only you can use your mark in connection with the goods or services you registered it for. And when you register your trademark, you register it into certain classes, which cover a range of goods and a range of services. Now, you can either register your trademark yourself, or you can get outside legal help, and they'll help you navigate the system and figure out the classes you want to register your mark in. For UK marks, you need to register at the UK Intellectual Property Office. Currently, it costs £170 to register a single trademark in one class. And for any additional classes, it's £50 per class. Now, this initial period of registration is 10 years. So you've got that trademark for 10 years. And you also have the option to renew it at a cost for further periods. Now, why should you register? Well, first of all, to be capable of registration, you need to make sure that your trademark is distinctive, it's not descriptive, and it's not similar to an existing mark where they've registered in the same classes or goods, classes of goods or services. I'll just pick out a couple of the, as you can see, many advantages. So first of all, it's easier to sue for infringement of a trademark. It's much quicker, cheaper, and less uncertain than a passing off action where you want to defend your mark. Passing off is used to protect unregistered trademark rights, so where you haven't registered yet. And you basically have to prove that you have a reputation in that mark and that the public associates it with your goods. That's a lot trickier than just having your trademark and saying, this is registered, this is what's happening. Now, good news is you can register a trademark before you start using it. So under normal circumstances, you can make the application prior to the product being launched. So if you've got everything in order, you can do that. There's a public record for trademarks. So if somebody wants to launch a new product, then they'll search the trademark register to check whether anybody else has registered or applied for the same or similar mark. And it avoids the danger that somebody else will register. So if you rely on unregistered protection and you don't register your trademark, you run the risk that somebody else will actually register the same mark. And then in order to stop that, you'd have to bring a claim of passing off. If you don't succeed, they'll be able to stop you from using your mark potentially, or you'd have to oppose the registration. So there are a couple of, well, there are many reasons why registering your trademark is a good idea. All right, so I'll cover patents quickly. Now, patents are designed to encourage inventors to publish details of their inventions and how they're put into effect. And it does this by providing them with a limited monopoly over their inventions, which means that nobody can sell or make the invention without the inventor's permission. This lasts for about typically 20 years, depending on where you are. And after that time, the inventions are available for the public to use freely. Now, to be registrable, a patent must be new. So the invention must not be made available to the public. And this means you shouldn't be showing off your invention at a trade show or anywhere, talking to your neighbors about it. Basically, apply for the patent first. If you're going to discuss it with anyone, you need to put non-disclosure agreements in place. Don't be going to a trade show and saying, oh, this is our new product, look how great it is, if you've not got a patent. They also need to involve an inventive step. So the invention must not be obvious to someone who's a skilled person in that area. And it needs to be capable of industrial application. So this happens where it can be made or used in any kind of industry. Now, you can apply for a patent on your own, although the application is quite in-depth, or you can get legal assistance, like in the case of a trademark. The owner of an invention is the only person entitled to make a patent application. So the person who's usually created it or their employer. So like copyright, with many inventions are made by inventors as part of the normal course of employment. And whilst their names appear on the patent, the employer will usually own it. Issue with contractors and consultants is that you'll always need to make sure you've got a contract in place to make sure the IP is assigned to you. And why you should seek protection. All right, so a patent gives you a monopoly right. It prevents third parties from operating within the scope of what the patent covers, also known as what the patent claims. The protection works even if third parties have developed their own technology independently and are unaware of the existence of your patent. Now, even where a patent application is unlikely to result in the grant of a patent in the UK, it can be used to deter third parties from inventing the same technology or using it. So you can highlight you've made a patent application by putting notices on your products or packaging, such as patent pending or patent applied for, which you might have seen on some products. And this identifies the patent applications that protect that technology. But don't do that unless you do actually have a patent pending, because it's an offence in the UK to represent that something sold is a patented product. Now, this patent will enable the owner to exploit the technology exclusively, either on its own account or by licensing to third parties. So it's a really extremely valuable asset. However, patents can take a long time to be granted. It's usually north of 2 years. However, you do have priority from the date of filing, so it will backdate your protection. They can also be quite costly. All right, let's hope the slides are working. Okay, so it's a bit geeky, but this is my favorite intellectual property, trade secrets. And they really do what they say on the tin. They can be protected under the common law of confidentiality, but there are also some newer trade secret regulations too. Trade secrets have to have the necessary quality of confidence, and the information has to be shared in circumstances where there's an obligation of confidentiality. So a prime example of this is Coca-Cola. So the recipe has been protected for, I think it's 130 years now. At one point, it was kept in a vault in New York, but now I think it's at the home of Coca-Cola. And only a few select employees know the recipe. The idea is that some of them know parts of the recipe and some of them know the other parts. So no one's got the full formula, right? So protecting trade secrets. The protection is so powerful because it can last indefinitely, as long as you keep that information confidential and don't share it with third parties. So basically, don't go telling everyone about it. For example, you can share select parts of a process or formula with different employees, so no one has that full recipe. You can use non-disclosure agreements to protect your trade secrets, and businesses might also consider security measures and training so that all employees are aware what should and shouldn't be going out into the public domain. Finally, we have design rights. These protect the appearance of a purely functional product without any aesthetic appeal. So think boilers or something like that. They're just, in my opinion, a bit boring. Now, there's a good example of a water bottle on here. So while the design right might extend to the shape of the nozzle in the water bottle, you can't get protection for the pattern on the surface of the bottle. So that will hopefully cover what design rights are to you. Now, the owner of a design right has the exclusive right, again, to reproduce the design for commercial purposes by making either articles using that design or a design document that records the design and enables articles to be made in the future, like an engineering drawing. A design right doesn't subsist until the design has been recorded in a design document or an article has been made. So the best practice here is to sign and date these design documents. Now, when you register, you'll get a 25-year right in the design. So it's a relatively short and inexpensive process when you compare it to getting a patent. If you don't obtain registration, you need to depend on unregistered design rights. I won't go into detail on that, but essentially, where a design right is unregistered, you'll get protection for 10 years from the end of the first year of exploitation. And that is IP in a very whistle-stop tour for you. Are there any questions?
Yeah, brilliant. Thank you. I do have a question, and it is regarding Kerrit's presentation at the beginning. There was no reference to the CIC. And would you be able to just tell us a bit about a CIC and what are the differences? Because I happen to know that there are some people within the project who are contemplating that within their, formulating of a business.
Yeah, so CIC is typically set up when there's a charitable sort of purpose behind it. So it's not a business that's set up for for profit at all. Obviously, I've done my research around CIC as part of my presentation.
CICs are more about they're special types of limited companies, and they exist to benefit the community rather than private shareholders, like Kerrith was saying.
But can you have a business and a CIC? As in, can you have a limited company and register a CIC?
So the CIC,
well, to be a CIC, yeah.
I think what it is maybe that's something you could, because it's probably not a fair thing for me to put to you now without giving you a chance to prepare. But if you could send that through to us, because I happen to know that that's something that's been contemplated by a couple people within the cohort and within the BAME community. When it comes to the food industry, there is that element of social enterprise that people want to bring into their business. So if you could do that for us and send it across afterwards, if that's better for you, that would be really helpful.
Yep, that's fine. Yeah, of course.
Thank you very much.
Can I ask, if someone came to you, said, what is the best time to go from sole trader to other types of trading vehicles? What advice would you give them? What would you suggest?
Obviously, it depends on the company's sort of life cycle and where it's at with its sort of progression. We would typically advise you do it as early as possible, really, just so the formalities are in there as soon as possible. So before too many contracts are set up, for example, you start setting up contracts with creditors, with suppliers and customers. You might have to then think about signing or novating those contracts across from the sole trader then to the company, and obviously then that has a procedure on its own. So it just means more work. So rather than just doing it, thinking, oh, well, we're gonna take a loan, for example, or now's the time to set up a company, we would just suggest that you do it as soon as possible, really, because it just means then the practicalities are sort of out the way early, if that makes sense.
Okay.
Yeah. And I can just add to that, Maggie. A number of our sort of beneficiaries have had some real teething issues when they've moved from sole trader to having set up a company, particularly around, and in one example, their bank decided that they were now too high risk now that they were set up as a company, and they had to rebank, which of course caused a sort of admin sort of follow on sort of requirements around that. So we're generally sort of encouraging people to set the company up ASAP, and especially if you're going to be spending anything on capital. So because there will be benefits from being registered as a company in terms of tax benefits, that could be quite helpful once you're set up as a company. So ideally, if you can see a significant amount of investment in kit, then you would really want to be set up before that.
Okay. Thank you.
Great.
I know you mentioned on the call, sorry, Andrew, but I know you mentioned about the number one legal pitfall to watch out for with the business going for growth. Now, for me, and it may be different for Gareth, but it's surprising how often these basic things are overlooked. Where is the value in your business? So does it depend on intellectual property? If it does, make sure you've got that list, make sure you register. If it depends on contracts and you've got lots of contracts with different providers, make sure you've got those contracts documented, make sure you've got them all in a file, you know what's going on, and you know your obligations under those contracts. Make sure you know what the other side's obligations are, the termination rights, what happens after termination, how you can negotiate any issues on the contract. It's just about knowing what the value of your business, where that value is. Sometimes it's in contracts, sometimes it's in information, it's all those different things. Oh, sorry.
So based on what you're saying, Sarah, it sounds to me, because I am so good at what I do, I can whip up a sauce or a spice in no time. But as far as value and all of that, we should be speaking to lawyers, is what you're saying, really. So having discussions to understand what you're saying.
Yes, exactly. It's just knowing where your value is. So it's about making sure you know where your value is and you're protecting that value, because if you don't protect it, you're at risk.
Okay.
I think
any advice regarding I think Charmaine's hand is up. Wants to ask a question. Charmaine, go.
Yeah. So I don't want to mind a question about the trademarking, but if you've got another question linked to that, Bernie, you go first. What was just discussed?
You carry on, love. Carry on.
So yeah, we've had actually an issue with trademarking. I'll put my camera on a sec. So we were contacted by the Earl of Sandwich, as it happens, because they actually trademarked the words Earl. So my business with my dad is called Earl's Kitchen. So this is when I was investigating, really trying to trademark the logo. And I spoke to the Intellectual Property Office, and they said that actually the name is too close to the word EARL. So what I haven't pursued really is finding out, would I, are there cases like this where people kind of just change the spelling of things, or is it something that I actually need to just go and rebrand the product if I want to trademark it? Yeah.
So
it's quite a big question.
What's the trademark you have at the moment, or the mark you have?
We don't have a registered trademark. The business is called Earl's Kitchen.
Okay.
Which is like my dad's name. But I know that the word Earl, and although they don't use the mark in the UK, they do have like a sandwich business in the US, and I think in France, actually, maybe the one in France isn't there. But either way, I pretty much know that we wouldn't be able to trademark the word Earl's Kitchen as it is.
Even though it's your dad.
So I didn't know if I sort of changed the spelling. Yeah, even though.
Can I come in here?
It's not sufficient.
Can I come in here? I would say this is where the advantage of a copyright or an IP lawyer helps, because I had the same problem. I went to trademark Maggie's, and the company Maggie fought against that quite seriously. So even though it's completely different, it's Maggie's and it's the design is different, but I was doing an African twist. So eventually what my copyright lawyers did was, we now have Maggie's with its strap line, an African twist to your everyday dish, and Maggie is not supposed to appear without that. So I'm just telling you what, but I wouldn't have sorted that out on my own. I had to use an IP lawyer.
Yeah, so that would have been my advice as well. Talk to an IP
I guess that's
lawyer.
what I'm asking, really. Like, I guess that's what I'm asking. I mean, is it definitely? Are there workarounds around it? That's so. I guess
there are definitely workarounds. Yeah, there are definitely workarounds. I mean, now I know when you refer to kind of if you have in your trademark Queen or King, those kind of things, that they have to go through special permissions. I'm not sure about Earl on where that stands. And it depends on how that's spelled as well. But yeah, so you'd have different things. So you'd add something to make it distinctive, or add the logo in the background, that kind of thing. And you'd make sure you are registering in areas that you are actually providing goods and services. So there's like one of the classes is for cakes and biscuits and that kind of thing, and then different things like that. So there are workarounds. It doesn't mean that you just can't register it. You just need to kind of differentiate it. But if you want to drop me an email after, I can also put you in touch with a trademark attorney who will help you.
I think, Maggie, you got off really, really lightly, because they could still easily have thought that and said, well, people are going to think it's us with an African twist, because Maggie does food. I know the Maggie brand. So you are very fortunate to have gotten away with that, as they call it, workaround.
Yeah, they tried to limit the categories we were in as well. But I'm telling you, I left it to my IP lawyer, and I'm so pleased I did.